So I just spoke with someone who told me that the last attorney they spoke to told them that even though they went to a trade show a week ago and displayed their invention at that trade show, that they still have about a year to file for a provisional patent application or utility patent application. And they were told this because we're in what is sometimes called the first to file system. Some administrators at the patent office will tell you it's a first inventor to file system, but to be honest with you, the way this works in the real world is that it's just a big trap. So let me explain why. Once you've made your invention public in one way or another, somebody might move forward and file for a patent application after seeing your invention before you get a chance to file for a patent application. If this happens, one of two situations will be true. Either they will actually be an inventor and they had the idea before they went and saw your trade show display, or they read the article about your invention, in which case they just hurried and guess what, they get a patent. Or if they're actually not an inventor, they saw your trade show display and they just straight up lied to the patent office. Even though they're not an inventor, they probably just killed your ability to get a patent on your own idea. But let's say that they don't even file for a patent application. This is a competitor that just saw your invention on display at a trade show, or they just read an article about it, or maybe just read your blog and maybe you posted something up about it. Well, if it's a clever competitor, they might just file a responsive blog to your own or to your trade show display, in which they describe your invention and they say, I didn't improve all these things about it. And as you can probably tell from the slash lines I have here over the words your invention, they just killed your opportunity to protect your own invention because they published an article. So even though you have a 1-year grace period after you make a disclosure to file for a patent application, guess what? You have 0 grace period as to anybody else's publication or disclosure of that inventive idea. And that's what catches people off guard. So this story about we're in a first to file system, let me tell you, it's a trap, and it's an easy trap to fall in. So don't fall for it. The other thing to take away from this is before you make your disclosure, you're going to want to call your patent attorney, call my office if you are a client of mine, and let's discuss what it is you're planning to disclose. And we're probably going to want you to file, and you're going to want to file, a provisional patent application or a utility patent application before the trade show, before you post a blog, before you make your first sale, before you do anything that's public with your idea and invention. So if you have a general comment, leave it below. If you have a specific question about a disclosure you've already made or are about to make, don't leave a comment below. Call your attorney or call my office. And otherwise, I look forward to seeing you in the next video.